Hello everyone and welcome to RTO Doctors 30 Days 30 Tips second series, and tonight I have decided to talk to you again about the whole Section 8 ESOS Act and RTO registration issue. Subsequent to a few tips that I've given on this topic over the past 30 days, I'm getting increasing numbers of questions about providers who are quite rightly concerned about where their compliance might be at in relation to Section 8 ESOS Act breaches, given that they're not CRICOS providers and this is a whole new area being explored and stringently audited by the regulator. And so I thought that I would examine it a little bit further, also because I've heard a lot of people say, but it's not our responsibility to ensure that they're not overseas students before they enrol in our programs. And so I thought that it would be important to take you back to the relevant clause of the RTO standards and where it's appearing in audit reports and where ASQA are starting to nail providers, for want of a better word, in relation to Section 8 of the ESOS Act. So I have my few notes here, but basically it all revolves around, and sorry, this is primarily for people who are not CRICOS providers and do not have CRICOS registered courses. So if you're a CRICOS provider, this is probably not entirely relevant to you, but it is primarily directed at those people who are not CRICOS registered and have not got applications in to be CRICOS registered. They're just domestic RTOs, or they might deliver offshore, but they have nothing to do with CRICOS registration whatsoever. And so their only regulatory requirements for registration are usually around the areas of the standards for RTOs 2015. Now, obviously, if they've got other legislation to do with occupational health and safety or work health and safety, that's a completely separate issue. But what we're talking about here is the vet quality framework and the legislation that applies under that. So where ASQA are picking up this issue around Section 8 is primarily under Standard 8, and obviously after that it's Standard 2. But Standard 8 talks about being legally compliant at all times, and it's really about consumer protection and making sure that the RTO is compliant with any legislation that is relevant to its operations, but also to ensure that students are confident that providers are compliant with any legislation that applies to their registration, and also that they are legally compliant to do with anything to do with training in relation to the student's enrolment there. But more specifically, the clause that is coming up under Standard 8 is Clause 8.5, which talks about being compliant with Commonwealth, state and territory requirements relevant to the RTO's operations. Specifically, Clause 8.5 states the RTO complies with Commonwealth, state and territory legislation and regulatory requirements relevant to its operations. So in the user's guide for the standards for RTOs 2015, we find that there is a clear statement there that says legislation, regulation and standards related to the delivery of training to overseas students. So if you are delivering training to overseas students, it makes it very clear that you should be around that legislation and what you're entitled to do, what you're not entitled to do as part of the enrolment process with overseas students, and what an overseas student is. So in some cases, you can have overseas students who might be here on a tourist visa or a working holiday visa, or you might have overseas students who are living offshore and you're delivering those qualifications or short courses offshore. But this specific topic that we're talking about here this evening is around the area of overseas students who are overseas students as per the ESOS Act and the migration regulations. So they're here on a student visa and their purpose is to study on a student visa. And so the user's guide is very clear about the legislation, regulations and standards related to the delivery of training to overseas students and how RTOs should be compliant with any legislation relevant to its RTO operations, relevant to that particular area. So what are the implications for RTOs then? They are required to make sure that if they're delivering training to overseas students under the ESOS Act and the migration regulations, that they are a CRICOS provider and the course is CRICOS registered. But what does that mean for a whole lot of providers out there who up until now have always been able to deliver short courses, for example, in first aid, barista, RSA, white card, high-risk work licenses, working safely at heights, manual handling type courses, all of these short courses that all lead to direct employment functions, and many employers will often require certain staff to engage in these short course training programs to update their skills, to make sure that they've completed some sort of induction program, or as part of a legal requirement, for example, if they need to do an anaphylaxis unit, for example, or if they're working in aged care and they need to do a manual handling unit or something along those lines. It is exposing a lot of domestic providers to regulation that previously has not been enforced. So I guess the issue then is that ultimately what I'm saying, there are quite a few large RTOs around the country who need to really start looking at their enrolment processes and looking at the potential for overseas students to have enrolled in their courses and how they're going to prevent overseas students who meet that definition under the ESOS Act from enrolling in courses in the future if they're not going to be a CRICOS provider and those courses are not CRICOS registered. It certainly leaves a lot of people exposed. So the next thing that I wanted to really talk about was how are ASQA auditors finding out this information? You'd be surprised how easy it is. So all the auditors need is to have a student's name and date of birth, for example, and they can go to the back end of PRISMS, which is the database that is common between the regulator, immigration and CRICOS providers, for example. And domestic providers don't have access to that database, by the way. But all they need is a student name and a date of birth, and they can plug in those details into the back end of PRISMS. And if the student is an overseas student on a student visa, their details will come up. And if they can match the information on the student to what's already in PRISMS, then there is almost a guarantee that that student is or was a student visa holder at the time. So how are they finding out? Well, they're finding out through student file audits. When the regulator goes in and does a site visit, they go through your student files. They go through your HR files to review your trainer and assessor qualifications. They go through your timetables. They go through your session plans. They go through audits of other providers. Recently, there was a TAE amendment to scope process. So if you submitted an amendment to scope for the TAE 40116 and you had to submit all of the records for the past 6 months, for example, and there are international students in there, there's a high chance that you are potentially being exposed in that data as well. There's a whole range of different ways that they're finding out. They could be auditing another provider entirely, and a student has, for example, in their application, a testament or record of results or a statement of attainment from your RTO, and it's very clear that that student in this new application is an overseas student, but your RTO didn't have CRICOS registration, and so it becomes apparent that you are delivering qualifications or courses to international students on a student visa without being CRICOS registered by the mere fact that that person had a certificate in their application documentation with a CRICOS provider. And so it's getting picked up in all different areas of the industry right now, and it's something that everybody needs to be really vigilant about and very concerned about. And you need to be making sure that where you haven't got processes in place already, that you are implementing processes that will prevent international students on a student visa from enrolling in your programs if you are not CRICOS registered. Now, this problem has been going on for the last 12 months. We've been talking about it. Some of us more experienced practitioners in the industry have been talking about it, and we've been saying to people, this is the way it's being interpreted now. You need to be really mindful of this. You need to put processes in place to mitigate your risk. People are still, unfortunately, not hearing that message, and they're finding themselves exposed. So in response to the concerns that I've had over the past couple of weeks in relation to this area, and to the growing number of providers who are expressing concern that they may be at risk in this area, and the increasing number of audit reports that I'm seeing where the regulator is alleging a breach of the Section 8 of the ESOS Act requirements, I have decided that I'm going to put together a small package for an ESOS risk review. And where providers are interested in finding out more information about this ESOS risk review, I would strongly encourage you to either send me a message via the Facebook page or LinkedIn, YouTube, wherever you're watching this from, or alternatively, just contact us on the website and we'll be in touch with you as soon as possible. The idea is to be able to help you to mitigate your risk before it actually becomes that big an issue that it's blown out of control and your registration is cancelled. Now, don't forget, I'd like to just read out a part of Section 8 of the ESOS Act for you, because it's important that you understand what the penalty is for breaching Section 8 of the ESOS Act. Section 8 of the ESOS Act is providing or promoting a course without being a registered provider. A person commits an offence if the person provides a course at a location to an overseas student, or makes an offer to an overseas student or an intending overseas student to provide a course at a location to that student, or invites an overseas student or intending overseas student to undertake or to apply to undertake a course at a location, or holds himself, herself, or itself out as able or willing to provide a course at a location to overseas students, unless the person is registered to provide that course at that particular location, or the person does so in accordance with an arrangement that the person has with a registered provider for that particular course, for that particular location. Now, the penalty for that particular offence is imprisonment for 2 years. So it is a very serious offence, and I'm going to copy and paste the link to Section 8 of the ESOS Act into the comments of the Facebook Live video and also the YouTube video, so that you can go there directly yourself and you can see what Section 8 is really about in the ESOS Act. And I'll also put a link to Clause 8.5 in the Standards for RTO's 2015 User Guide, so that you can see there where the linkages are. But what I can tell you, absolutely certainly, without any doubt, is I'm seeing more and more audit reports come across my desk with a notice of intention to cancel because a provider has been issuing qualifications or statements of attainment, or they've been enrolling international students on a student visa into courses without being a registered CRICOS provider and without the course being registered on CRICOS. So I hope that you take tonight's tip with the sincerity and the significant concern that is being raised in the industry, and that you're able to strengthen your systems and processes to ensure that you're not one of the unlucky ones that is caught up in this change to process by the regulator. And again, if we can be of any assistance to you whatsoever in trying to identify your ESOS risk, please don't hesitate to contact us, and we would love to be able to help you out in any way possible before it gets too late. So thank you for listening tonight. Have a wonderful weekend. I think we have one more session of 30 Days, 30 Tips, and that will be it for the end for the second series. So thank you for joining us, and I look forward to seeing you again tomorrow. Bye for now.